Good afternoon, ladies and gentlemen. Welcome to the session this afternoon. I hope you can all hear me. Well, thank you. Thank you for joining us. As I said, on behalf of Greatsoft, I'd like to welcome you to the SARS Project AmaBillions Audit Preparation webinar series. This presentation will be an hour and a half, including some questions and answers time at the end. So we'll aim to finish the session at 4:30 this afternoon. If you have any questions, please put it in the Q&A box. We'll keep an eye on it, and then we'll deal mostly with the questions at the end, unless there's a question that pops up that's relevant to the part that's being presented at that point in time, and then I'll make a call to interject to ask that question. Right, this is the third and the last in our series. This edition is entitled Managing a SARS Audit from Verification to Objections. The previous two seminars is recorded and has been placed on our website. So if you'd like to see the previous two webinars, please go to www.taxrisk.co.za. Then you can navigate to the media page and you'll see the recordings of the previous two sessions on our page. The previous two sessions, the first one was held on the 15th of October. It's entitled Understanding the SARS Audit Process and Tax Risk Triggers. And then the second one in the series was on 22nd of October, entitled Corporate Income Tax Audits, Transfer Pricing Audit Trends, and Defense Strategies. So by all means, go have a look at it. This edition is also recorded and will be placed on our website within a few days of the completion of this. I have been asked a few times by people about your CPD certificates. Those will also be issued in a few days. Just give it a few days for the team to process it. There's quite a number of certificates that needs to be processed. So I ask you to be patient. If you haven't received it within a week, you're more than welcome to send me an email and then I'll follow up on that for you. So why is this series important for tax practitioners and companies? As we know, the South African Revenue Service has announced that its intention to collect an additional 75 billion rand in tax revenue. Historically, such targets have led to intensified tax audits, particularly targeting large corporates and high net worth individuals. So in anticipation of a significant increase during the 2025-26 fiscal year, this webinar series has been designed to help tax practitioners and corporates navigate the audits effectively and to defend your positions. So without further ado, I'd like to introduce our keynote speaker for today, Dr. Daniel Erasmus. Dr. Erasmus holds a PhD in tax and constitutional laws and serves as an adjunct professor of international tax and transfer pricing. He specializes in tax controversy with a broad focus on complex domestic and international tax matters and a particular emphasis on tax disputes and tax risk management. With over 30 years of experience, his expertise spans all aspects of tax planning, administrative proceedings before revenue authorities, and tax litigation. Dr. Erasmus, thanks for joining us today. We look forward to hearing your presentation. Welcome.
Thank you very much for that introduction. Some of you may have attended the previous two seminars, or webinars, should I say. This series is based on an in-person series of seminars I conducted in South Africa early in September. Obviously, not everybody could attend those particular seminars, so we decided to conduct these by way of webinar, and thank you to Greatsoft for being the host of the series. I'm hoping and expect most of you to be clients or prospective clients of Greatsoft that will give you the background technical, should I say, platform to handle whatever you need to do in your interactions with SARS. And my two previous webinars were prefaced very much on preparing for audits, what the audits look like, and really the most important aspect, I would say, that emerges from those two webinars is the importance of tax risk management. Now, those are very pregnant words, and I'm going to share something with you in a minute to show you what that entails. I expect most of you can see the slide pack on the screens. I like to run it this way so I can see what the next slide is. Willem, can you just confirm that you're able to read the text clearly?
Yes, that's perfect. Thank you, Daniel.
All right. So tax risk management is really something that I guess is more geared, it should be geared for all taxpayers. But again, many of us are smaller taxpayers. We just don't have the time or the money to be able to engage on these projects. So the tax risk management process is something which is really embarked upon by larger taxpayers. But many of you in this webinar series are advisors, either by way of doing the tax return preparations and or the record keeping and financials of your clients. And certainly there is a lot that you can take away from the tax risk management process that you should be embarking upon for your client base. So what that would mean is typically, you'd be able to group certain types of clients into one particular category and identify key emerging tax risks, and then be able to plan for those going into the future. And just to give you a little bit of practical insights, this is a process that I developed some 2 decades ago. I headed up a project for a very large beverage company. They were facing tremendous backslash in the media with one of the sort of whistleblower type entities that emerged in the UK that said that this particular corporation was not paying its fair share of taxes in Africa. And they had looked at what the published results were, and then looked up how much taxes were being paid. And of course, tax legislation, being as complex as it is, gives many of these entities opportunities to plan around paying high taxes. And there's nothing wrong with planning your affairs in such a way to minimize your taxes. That has been a feature of common law, case law emanating out of the English courts for many, many, many decades. And the reason why it was necessary for revenue authorities to develop anti-avoidance provisions inserted into the tax legislation as we see it today. And one of the most prevalent that is being used at the moment for multinationals is the sections on transfer pricing. So there's absolutely nothing wrong with planning your tax affairs to minimize the tax, because they have to then have you fit into the general anti-avoidance provisions, which ultimately says if the reason why you've structured a particular transaction in a particular way is only to save tax, then they can set aside and recategorize that transaction so that you would pay the taxes that would otherwise be paid. But if there are very sound commercial reasons for doing what you've done and the plans that you've implemented, then so be it. Be that as it may, this particular corporation faced exposure, and they asked me to spearhead a project for their Southern African operations to identify any tax risks that were prevalent or present, even though they may not have come to the attention of the audit committee or the other committees reporting into the audit committee. And that was then repeated in Hungary and in Romania, and it was then offered to the other subsidiaries worldwide. And in that particular process, we developed a system to identify tax risks and to then create a process to do so and how to deal with them. And cut a long story short, when we found that mistakes were made by the corporation, we identified why those mistakes were made. How was it that this hadn't been reported before, and then identified how this would be picked up in the future. And then we would go cap in hand to the Revenue Authority. It was before the voluntary disclosure process was in play and had been legislated. And we were then able to approach the revenue authorities and say, listen, this is what went wrong. This is why it went wrong, importantly, and this is why it will not go wrong in the future. We're offering to pay the taxes that we hadn't paid, and we're looking to minimize our penalties and interest. And from our recollection, in I think all of the instances, we got around paying penalties because we had self-disclosed. Obviously, there was an interest component, and that's how I developed the whole process that forms part of my book called Tax Intelligence, copies of which are available to you in PDF format at no charge. That really unpacks the detailed tax risk management process. But what I wanted to share with you is I, act as chairperson in a number of tax risk management committees for listed and other multinational companies. The reason for that is one of the very important aspects of tax risk management is because you are looking through the organization at potential litigation that might emerge between the organization and revenue authorities. It is important that a tax litigator such as myself is involved to give the direction so that the material that is discussed in that forum, that is exposed in that forum, is subject to the attorney-client privilege, which means that that information does not have to be shared with any authority such as a revenue service such as SARS. It's something that is kept private to the company, and for very good reason, because revenue authorities would love to get their hands on that documentation because it would give them a blueprint of where they could potentially audit that company. However, having been in one of those meetings yesterday, the very interesting fact emerged. The CFO of this very large listed multinational corporation said, but why is it that we have no tax provisions for our biggest tax jurisdiction? And the answer to that was that the tax risk management process has been running for 2 decades, and it has resulted in that particular revenue authority realizing that we play open cards, that we are a trustworthy taxpayer, and for that reason, we do not really emerge on their radar screen as an entity that they need to audit on a regular basis. And that's really where we want to be as taxpayers, particularly large taxpayers. Interestingly enough, all the tax provisioning for that large multinational exists in the African continent, because their process there's 2 reasons for it. Hasn't quite got to that level, and secondly, the revenue authorities throughout Africa, outside of South Africa, are particularly aggressive. And what we're finding is that they are raising assessments very quickly in order to show their Treasury or ministers of finance that there's are large collectible amounts of money for their particular balance sheet, and they are skipping and jumping over essential steps that need to be taken, and putting the taxpayers on a back foot, and the taxpayers are not properly educated to know and understand the procedural defects that they could hold these revenue services accountable for and have those particular assessments set aside. And those of you who operate in Africa will know many of the jurisdictions, before you can even enter the objection and appeal process, you actually have to pay a portion of the taxes that have been assessed. So if it was 100, you would have to, in some instance, pay 20 or more % of that before you could even initiate the objection and appeal process. And as I've mentioned in my earlier lectures, there is a very important step that needs to be taken by, in my view, all revenue authorities. We've seen it apply in South Africa, and notwithstanding the fact that it is entrenched in our legislation, many of you as advisors and taxpayers are completely unaware of this particular requirement. And I get asked a million questions about this. And even when I've explained it, it's as if it doesn't sink in. People are not aware of this really imperative step that a revenue authority has to take before it raises an assessment, a revised assessment against you. And I will be going into that in detail, as I mentioned in my earlier webinars. So I wanted to just say that tax risk management really ultimately results in you achieving a situation where you have a relationship with the revenue authority where you're not going to be inundated with tax audits. Now, that doesn't apply, or that doesn't really apply to you as the smaller taxpayer. So what do you do? And as I've mentioned, your advisors hopefully would put you in a basket of similar taxpayers and identify areas of risk that they should be monitoring and sharing with you, and making sure that those areas are properly covered. But as a backup to that, and this is one of our other co-sponsors, and Willem is going to give you a short presentation, Willem, before we take questions at the end of this webinar, is taxrisk.co.za. And taxrisk.co.za is a facility that I was involved in setting up nearly 2 decades ago, for the very reason that I was not in a position to act for smaller taxpayers simply because they cannot afford the expertise that we have. And it's not just me. I work with a team of people that have different responsibilities, and all of them have fairly high charge out rates when it comes to charging by the hour. And you as a smaller taxpayer just cannot afford that. And so I tried to figure out, how do we do this? How do we create some sort of contractual relationship where we can make that expertise available to you, the smaller taxpayer, that it doesn't cost you these heinous sums of money to get the representation that you should be getting? And the answer to that was to create a short-term policy whereby we would then have a large collection of smaller taxpayers paying low premiums into a policy, and out of that policy pot, a percentage of you would then be hit by SARS audits, and that small percentage could then be represented by us, because the insurance entity then pays our fees, and you don't have to pay those fees, but you get proper representation. So it doesn't cover you on the taxes, but it covers you on the representation that you are required or should have from the moment, and I listen to me carefully, from the moment the SARS audit commences. And I'm going to explain to you very carefully the differentiation between a verification and a proper tax audit, and when that switch takes place. And this policy kicks in when that audit commences, when SARS is now looking to raise an assessment against you, and in many instances simply just raises the assessment against you and then does not take the necessary steps that are required. And that is where we kick in and help you immediately, so that it doesn't matter how small that assessment might be. It's not small for you. Let's say it's a 30,000 Rand assessment, but in order to switch our engines on, it's going to cost you 80,000 Rand. So you're not going to do it. But if the policy is there, you will do it, because you're not going to pay the 80,000 Rand. And Willem will take you through what those premium costs are, but they literally start at just over 200 Rand per month, honestly, which is, like, you know, I say, it's 3 or 4 cappuccinos in South Africa. It's really a no-brainer. And yet I don't see the floodgates opening, and I just don't understand it. For some reason, is it because the advisors think that they might be seen to be incompetent? No, you as advisors are highly skilled at the merits of compliance and knowing what to do when it comes to the sections in the Tax Act, such as the objection and appeal processes. But with the greatest of respect, you are not skilled in constitutional and administrative law that applies to the audit section that takes place. And we will look at that section 40 onwards in the Tax Administration Act. And that is where the tricks of our trade kick into play. And you don't have to go and spend thousands upon thousands of rands to access that expertise. You can simply do so by paying really a really small premium every month. And it's just a no-brainer. I mean, you know, everybody that has any kind of attachment to me, I've had them buy the policy because it's just worth it. It's worth every single cent. So really, please look into the taxrisk.co.za policy and consider implementing that, whether it's a family trust, whether you are a high net worth individual, a small business. All of you are open to attack and scrutiny. And you would have seen with the AmaBillions project, many of you have received notifications asking you to reconcile the information that they have drawn through their AI systems from your bank accounts. They've tallied up an amount for a particular year in question, compared it to your submitted tax returns, and said, hey, there's a discrepancy. We need you to explain this. That's your typical verification audit. And you now have to put in all of that effort to explain it. And that explanation is something that you would have to do with your advisors. But as soon as that explanation has been submitted, it is absolutely essential that you notify SARS through the e-filing process, through your advisors, that on the submission of the answers to what they have queried on that reconciliation, they need to take note of the provisions of Section 42 of the Tax Administration Act. And Section 42 of the Tax Administration Act, which I will share with you in a little while, says that they have to keep you informed of any tax audit going forward. And so that would mean if it now becomes a proper tax audit, and if they decide to make any material change to your tax assessment as it currently stands, that material assessment, before it's triggered by a revised assessment, they are duty bound. They have to. It is law. It is law. They have to issue you with a letter of findings explaining what it is they propose doing. And they have to give you a period of time within which you can respond. And they have to look at that response and consider it and look at what you've written back before they push that button and issue the revised assessment. And failure to do so on the part of SARS is a major problem for them, because that revised assessment becomes unlawful. Now, that's great. It's great to hear all of this information, but unless you take the necessary steps to have that assessment declared unlawful, and that's where the problem comes in, they just carry on. And the law protects them in that regard. If you've got rights and you don't stand on those rights and you don't claim them and act on them, then the law says things carry on as per usual. They will then expect you to object, to appeal, and go the long form and have the pay now, argue later rule implemented, and all of those horrible things come into play, when in fact, by means of a simple step, because they have overstepped their powers by not issuing a letter of findings, in the very simple example I've given you, which happens all the time, that assessment can immediately be set aside. But it means taking the necessary steps to do so. And there are steps that we as litigation lawyers in the field of tax law, and one of our other sponsors is Daniel Erasmus, which is a dedicated tax attorney law firm that specializes in this type of work. And they are one of the specialist firms that we would employ through taxrisk.co.za to immediately step in and take over the process with your existing accountant advisors to have that assessment set aside. But we have to take those steps. We have to switch those engines on. So again, please do not take this lightly. I'm going to emphasize this point throughout this particular webinar today. Now, in the process of preparing for this webinar, I realized that many of you just don't have the time or the inclination to do any sort of advanced courses. But needless to say, I am going to share with you I'm going to share with you one of the courses that I run through Middlesex University in London. And you'll see on the screen, and this is just a page of one of the short courses we run, Conducting a Transfer Pricing Trial. The other one that we are currently starting up is basically called The Mechanics of Tax Risk Management. And I've given you sort of the first page of lecture 2, where you'll see there's a tremendous amount of additional reading that we give delegates to do. And then we introduce them to the whole process of tax risk management, a very detailed 16-week course, which honestly is something that any of you advisors should at least have someone in your particular practice enroll in this course, and then share that information with the rest of you. That is where ChatGPT is very, very useful. When you get these detailed notes, and you'll see this particular unit runs into 74 pages. You simply put this particular set of notes into ChatGPT and you ask it to summarize it, and it will come up with a fairly accurate and decent summary that you could then share with the rest of the people in your in your practice, and then sort of dig into the steps that should be taken. But basically, it identifies and goes into the tax risk management steps. I'm not going to bore you with the details. I wanted to just give you insights that this is available. If there is any of you that would like to look at these short courses, please reach out to me or to Willem, and we will put you in touch with the administration so they can share that with you. It would be negligent of me not to at least tell you about that. But in addition to that, in the process of preparing for this lecture, something which I thought I would share with you is LexisNexis and Nico Toron published a book called Practical Guide to Handling Tax Disputes. And I found this to be a particularly useful book. The problem with textbooks often, though, is they are just like our course, but it's required to be, are quite academic, but out of that, you're able to pull a lot of useful information. And I wanted to just share this particular book with you. And I would suggest those of you who are advisors that you try and obtain a copy of this book and at least have it available in your library to reference to. It doesn't go far enough as far as I'm concerned, but it does cover section 42 fairly well, which I'm going to spend time on, and that is the letter of findings. So let me just put that up again. A very good book for you to have in your libraries, Practical Guide to Handling Tax Disputes. And then every single one of you should have a copy of this very important piece of legislation. And that, of course, is the Tax Administration Act. The Tax Administration Act governs most of what you do from a tax point of view, except in terms of customs and excise. So customs and excise is its own specialized area. And it's important that you're able to reference and read some of the important sections. And again, I reference section 42, which I'm going to take you through in a little bit. So that was just by way of sort of an important introduction to what we're doing. Now, as far as the objectives go, what I'm hoping to convey is that you will understand the various stages of the audit. You will learn, know, and understand your legal rights and duties under the Tax Administration Act. You will learn how to manage and any requests by SARS in a strategic and lawful manner. You will be able to prepare well-written responses to your letters of objection and then the actual objection themselves. And in the process, I will be referencing some key cases that I would suggest at least your advisors should take a look at. So basically, we're looking at the commencement of a verification audit, turns into a proper audit. You then issue with a revised assessment. You would then have an opportunity to object, and ultimately it goes onto an appeal where you would have the opportunity to try and resolve this by way of an alternate dispute resolution process, which in the past has not been very effective, but of late, in complex matters involving transfer pricing, I have been successful in ADRs with SARS in reaching a particular settlement. So don't discount it. Then, of course, the tax appeal means that is when you end up going to a tax court ultimately, and that could take a very, very long time. I just finished off a very important transfer pricing case on the 19th of August this year, and it would have gone further had we not settled with SARS favorably for the taxpayer. It was the very well-known transfer pricing case that I was involved in, and the case had been running for 11 years. We only went to trial in 2023. The judgment was issued the beginning of 2024, and August of 25 is where that judgment was taken on appeal to the Supreme Court by SARS. And had we proceeded with the Supreme Court appeal, win or lose, either party would have taken it one step further to the ultimate court, which is the Constitutional Court, and we probably only would have appeared there probably late next year, 2026, early 2027. So think about that. That's 12, 13 years in the making, and no one wants to be involved in that type of lengthy dispute. So as much as I'm sharing with you what the objection and appeal processes are, at the end of the day, I want to place you in a position where you are able to eliminate that early on in the process. And that is through a proper tax risk management process, a proper engagement with SARS at the time that they conduct the audit. There's no reason why in the process of the audit, if you find that anything has gone wrong and you need to come clean, that you can't do so by way of settlement discussions with SARS to eliminate the possibility of having to go this lengthy process of going to a tax court. It just is a terrible an experience for any one of you. All right, so legal framework. So here I want to look at the Tax Administration Act itself. And so let's start with, let me just make the wording a little bigger. And these are sections which most of you may not have ever seen before, maybe have seen it a couple of times. And I would suggest every single time you are going into an audit process that you remind yourselves of what the section says. Section 40 says SARS may select a person for inspection, verification, or audit on the basis of any consideration relevant for the proper administration of the Tax Act, including on a random or risk assessment basis. Now, the relevant for these words are pregnant with meaning. So there's got to be some sort of nexus between something that SARS has identified. It might be something in that industry, it might be, and usually that's what it is, it might be something that has come to their attention, it might be as a result of their AI data processing system that they've picked up something. My example is they run an audit on your bank accounts and they see that the balances for 2024 don't equate to what you have put into your tax return for 2024, and they ask you to explain that. There's some logical, rational, reasonable reason for them doing it. It's not just a stab in the dark. So when they talk about random, doesn't mean that they can just simply spin a wheel and target you, and that's not what they do. They would be wasting their time. There's got to be some basis for them selecting you in the first place, and that becomes important in the process that then evolves beyond that. So I want you to bear that in mind. Relevant for the proper administration of the Tax Act, and you can highlight those words because those words are also defined in this legislation, and I'm not going to go back. You can reference those definitions yourself. But in addition to that, even where a word is defined, those words usually have also been the subject of a particular tax case or an inquiry. And so one would need to look at what the tax law or the case law says about what is meant here. And I'm going to try and cover some of that with you. Then Section 41 talks about the authorization for a SARS official to conduct an audit or criminal investigation. And in my previous webinars, I mentioned this sort of area where a civil audit, a normal tax audit, can potentially become a criminal investigation. And the point that I made to all of you, if you were listening in those earlier webinars, when SARS makes that switch from a tax audit. So remember, we started with a verification audit. I'll come back to that. Now we're in a tax audit and they decide to conduct a criminal investigation. That switch is a very important switch. And the moment that switch is made, your rights become a lot broader. Let me explain. The Tax Act and the Tax Administration Act is one of those pieces of legislation that gives a government authority immense powers beyond anything else. Think about it. If the police or any division of the police want to investigate a criminal, they cannot just barge into a criminal's place of residence or work or whatever and start demanding and extracting and taking information. They would normally have to go to a judge and obtain a search and seizure warrant, which means, we go back to section 40, they have to explain to a third party, a judge, why they believe it necessary for them to barge into those premises and start attaching documentation because they believe some sort of crime has been committed. There must be some suspicion that is based on some sort of objective facts that exist that they can place before the judge. A judge should not typically just issue a search and seizure warrant to allow them to attach this information. What happens in the tax acts? They can simply write to you. They simply write to you and they say, Mr. ABC or ABC Pty Limited, we want you to give us information regarding the following. And if you do not give them that information and you have it at your disposal, that in itself is a criminal offense in terms of the Tax Administration Act. So they are compelling you. They are compelling you to give information which might be incriminating. So it might be that some of that information, when handed over to them as an authority, might trigger certain criminal provisions against you, of which there are many in the Tax Administration Act, many in all the different tax acts that exist. And notwithstanding that, they don't have to go and get a search and seizure warrant. If they got a search and seizure warrant, whatever information they extract from your premises, they're able to use in any type of criminal prosecution against you. But the moment they compel you to give the evidence over, there is a guarantee in our constitution, which comes from many other constitutions, that you can never be compelled to give self-incriminating evidence, whereas now you are being compelled to give self-incriminating evidence. So what that means is that there has to be a quid pro quo on their part. So because they're compelling you to give self-incriminating evidence, the law then says they cannot use that evidence as evidence against you for committing a crime. Okay, so think about that carefully. They can use it to raise revised assessments, and they can use it to get extra interest from you. They can use it to get extra penalties from you, all of which exist in the various pieces of tax legislation. But they cannot use it as criminal evidence. Now, the people that are acting against you are not all aware of this. The prosecutor who ends up with the file and ends up with the job of prosecuting you for criminal offenses was not typically involved in the investigation stage, and he or she won't know at what point did this tax audit investigation become a criminal one. And the moment it became a criminal one, there's a Chinese wall, there's a separate file that should have been created where the self-incriminating evidence given by you cannot be put into that criminal file. And so SARS is unfortunately using criminal prosecution under the Honey Badger project, which they've launched recently in various jurisdictions, to pursue criminal charges, particularly against officers of corporations. So this is something that you need to be aware of. You need to be aware of this differentiation. And again, I reference you to getting very early representation. So from the time that the tax audit commences and your hand is being held by tax litigation attorneys who are aware of these nuanced differences, they can ensure that this hand-holding process places you on a path where you do not have to now face unnecessary criminal charges over and above a tax investigation that has taken place. So I went into that because we here SARS has to have authorization to conduct an audit or criminal investigation. So here it says that the official doing the investigation must be given written authorization. And that authorization is something that can, in fact, be asked of the individual concerned. So at the time, if they were ever to arrive at your premises for a tax investigation, which they can, as I've just explained to you, it's different to a normal police investigation. You are absolutely within your rights, but hopefully you've got your legal representative holding your hand to request. The only people that can be present and participate in that particular audit are the ones that have been given written authority to do so. And there's a specific document and it's a fairly generalized document that the official would have to hand over and prove, just like an FBI badge, to prove that they have been properly authorized to conduct this investigation. And at the same time, you're entitled to ask them, going back to Section 40, what this investigation is about. These are very important steps, and in the failure of them doing so, if the official has not been properly authorized, then that official shouldn't be part of that investigation, and anything that they have done vis-a-vis that investigation in itself becomes questionably unlawful. And so that opens a whole gateway in terms of various defenses you would raise against them. So these are important steps that SARS have to take on their side. Then we get to the very important Section 42. And here I want to jump to Section 42.2. We don't have enough time to go into everything. Upon conclusion of the audit or a criminal investigation, so on conclusion of the audit, this is an all tax audit or a criminal investigation. So let's just focus on the tax audit for the purposes of this discussion. And where the audit or investigation was inconclusive, SARS must inform you. In other words, they've got no. So in other words, once you've sent that verification information and it doesn't result in something that they need to do because you've explained it well enough, they need to tell you. They need to say to you, thanks for the information, reviewed it, no further steps will be taken. They have to do that. Guess what? And all of you are going to tell me this. They don't, but they're supposed to. So when you submit that information, go to Section 42.2a and point that out to them in the e-filing document, saying, now that we've given you all this information and it explains the discrepancy that you've picked up, we expect that you will inform us that there is no further conclusion to be drawn, and that whatever you were intending on investigating or looking at further, that this won't happen and that the matter will be terminated. We expect you to inform us of this. If not, and we now reference Section 42.2b, you do identify potential adjustments of a material nature, which means any adjustments to what your tax return or tax assessment was. SARS must read this within 21 days or the further period that may be required based on the complexities of the audit, which they need to tell you, provide the taxpayer with a document containing the outcome of the audit, including the grounds for the proposed assessment or decision, referred to in 1042, which is the revised assessment. So they have to document, and you are then given later on in this same Section 42 an opportunity to respond to that. That is absolutely essential. And this is the step that SARS messes up all the time. And this is the step that many advisors and taxpayers are completely unaware of. And you need to be aware of this. It is so important. Then we go on to 46, which deals with request for relevant material. And again, I said to you, relevant material is defined, and it must be material relevant to whatever it is they are investigating. So they need to create some sort of nexus between why they're looking at the information and what it is that is concerning them. And then sections 47 and onwards deal with seizure confidentiality. I'm not going to go into that. I've mentioned enough. They can, of course, go and get a search and seizure. They can run an investigation and an inquiry into your affairs. These are highly specialized stages, which we don't have time to discuss today. But I just want to re-emphasize, I just want to re-emphasize 42. So when it comes to the verification stage, I've explained to you a good example of that. And what you need to say when you submit that information, to say we're expecting you to come back to us to say that any further investigation has been terminated. If not, we are expecting from you a letter of findings. Now, although it doesn't use the words letter of findings, trust me, letter of findings is something that SARS knows very well. Willem, you've come up. Is there something?
Yeah, I have a question that's relevant to this conversation, Daniel.
Yeah.
And from Yaku, he says, as Section 41 verifications excluded from section 2, letter of findings. I want to ask what for you is the determining factor if an audit or verification of, what's the determining factor if it's an audit or a verification?
Yep. I've just explained that. I'm not sure why did that question come up after because then my explanation is not clear. So what I'm saying is when SARS asks for a verification, they're normally asking for numbers for you to verify something. And I'm saying when you submit that via e-filing, please go and quote section 42, especially 42.2a and 42.2b, and say, here are my numbers. As far as I'm concerned, I've explained the discrepancy to you. There should be no further steps taken by you. Please, can you confirm in writing that you're taking no further steps? However, if you are going to take further steps, then you fall under section 42.2b, and that means that you do need to give us a letter of findings. So what you're doing is you preempting. There's no fine line here. There's no definitive definition of a verification audit. A verification audit is just that. It's a verification of figures. So that in itself is not an audit. But the moment they take that information and do something with it, which translates into a revised assessment, it has become a tax audit. You're going to say, yeah, but they haven't audited anything further. It doesn't matter. They've gone and taken steps that materially affect the position of the taxpayer. Look at the section. Let's go back to the section. I want you to read section 42.2b. It says the audit identified potential adjustments. So audit doesn't say tax or verification. It just talks about an audit. So a broad audit here would include a verification audit. If they've identified potential adjustments of a material nature, that's when they trigger a revised assessment. Not so. I mean, that's obvious. So the moment they do that, they've converted the verification audit into a tax proper audit. You preempting them and telling them if they are going to do that, they need to issue you with a letter of findings. If they don't, then you immediately communicate with Willem or the appropriate broker that you've taken the policy through, or you reach out to ourselves and immediately to implement an application to set aside the assessment. That's what you're entitled to do. And I've been extremely successful with that, as I will share with you in a few minutes. Hopefully that answers the question. I'm happy to go back into it.
Yeah, because thank you. Much appreciated.
Yeah. So managing the verification. Again, you give that information, you tag on section 42.2a and b. There's not much more that I want to say there. Avoid escalation. When you're answering these things, be very precise. Be precise in what you give. Don't just give reams and reams and reams and reams of information. Just as much as you're asking SARS to focus specifically on telling you what the audit is about so that you can give them a focus-orientated response, so your response must be focused, and don't just give them general ledgers. Give them extracts of what is relevant to the question that you are answering. And again, I repeat, quote section 42a and b and explain what you need from them. And as I said, they will, even if you do so, they are going to trigger in many instances because the person who's conducting the audit has not been properly trained. They've not been properly trained. They've simply been told, hit these guys as hard as you can and as quickly as you can because we need more money so that we can buy more fancy sports cars for our politicians. And I say that tongue in cheek. So that's what they've been told. They have not been properly trained, in my view, from what I can see. And therefore, we must be able to stand up against them and set this unlawful conduct aside. And this conduct, and you might say to yourself, but how is it possible? It is one of the most fundamental rights that we have as individuals in South Africa. The Audi Ultram Partem rule: before an authority takes a decision that affects you, they must give you an opportunity to be heard. And that's the response. That's why they've got to tell you what they're going to do, and they must give you an opportunity to respond. And in that response opportunity, you have the opportunity to go in graphic detail to explain to them why they are wrong. Why they are wrong. Okay? So responding to the letter of findings, here I want to communicate with you some of the information out of the textbook that I mentioned to you. So let me just see. All right. So here on page 23, so this should make it easier for you, those of you who get hold of a copy of this textbook. New grounds on assessment. It often happens in practice that SARS, after considering the taxpayer's response to the letter of audit of findings, changes the grounds for its assessment. This would be evident from the differences between the letter of findings and the finalization letter issued by SARS. The question in these circumstances is whether SARS would be required to issue a new letter of findings were it to change its grounds of it should be proposed assessment. It is submitted that SARS would usually be required to do so. The mere fact that the taxpayer can lodge an objection to address the new grounds of assessment does not negate the taxpayer rights under the Tax Administration Act to an opportunity to respond before SARS raises the assessment. So we go even a step further. So you've got your letter of findings, you respond to it. And if SARS now decides to go into a new direction, it's got to issue a new letter of findings. And if it fails to do so, guess what? You can then basically have that assessment set aside. That is how strict the law is. You've just simply got to be in a position to apply it. Okay. I don't want to go to that one. The next one I want to refer to is right here. Again, this is I'm just so that you're not just listening to my say so. This is quoted out of this textbook. In the case, and this is an important case, in the case of Nondabula versus Commissioner for SARS, the High Court held that SARS is a creature of statute, and as such, it must operate within the four corners of the statutory provisions which empower it. SARS is governed by and operates in terms of the Tax Administration Act. It therefore cannot do anything not specifically provided for in the Tax Administration Act or some other legislation, nor can it conduct itself contrary to the provisions of the Tax Administration Act. In failing to comply with the Tax Administration Act, SARS acts unlawfully and unconstitutionally. I can't say it to you in any better way. Then on the points that I've just made on the prior slide, very important case for those of you who don't know it, the Pretoria East Motors case. At least three main principles can be drawn from the judgment of the SCA in the matter of SARS versus Pretoria East in the context of onus of proof. SARS must have proper grounds for believing that the taxpayer has not been assessed correctly before it can raise an additional assessment. The proper grounds principle. The taxpayer must at all times in the process leading up to the additional assessment and after the assessment know exactly what it is being called upon by SARS to prove, the informed taxpayer principle. And if SARS has based an assessment on the taxpayer's accounts and records, but has misconstrued them, the taxpayer would discharge its onus by simply explaining by way of appropriate evidence that the SARS understanding is wrong. That is where typically that would happen in the case of a verification audit. So again, a very important case. Take a note of this, Pretoria East, a good case for you to look at. And then the book goes on. I'm not going to spend any time on unpacking these principles referred to. That's something you can do in your own time. Here again is a further reference to the Pretoria East. Quote, the raising of an additional assessment must be based on proper grounds for believing that in the case of VAT, because it was a VAT issue there has been an under-declaration of supplies and hence of output tax or an unjustified deduction of input tax. In the case of income tax, it must be based on proper grounds for believing that there is undeclared income or a claim for a deduction or allowance that is unjustified. It is only in this way that SARS can engage the taxpayer in an administratively fair manner, as it is obliged to do so. It is also the only basis upon which it can, as it must, provide grounds for raising the assessment, to which the taxpayer must then respond by demonstrating that the assessment is wrong. Very important. Now, how does this play out? So again, there's been recent case law in the Constitutional Court to say that if you have a tax dispute, normally you have to go the objection and appeal route to go to the tax court to address the merits of the matter. However, if it is a question of administrative law, in other words, we are looking at the conduct of SARS, where SARS, and I'm giving you the specific example, SARS has failed to execute the peremptory provisions of Section 42(2)(b) by failing to issue a letter of findings, then you are entitled, that this would fall under PAJA, the Promotion of Administrative Justice Act, and this is a case that you can bring directly to the High Court, not the tax court, and it's by way of application, which means you don't go through the whole objection and appeal process. You draw up an application supported by affidavit explaining the steps that SARS has failed to take, and in doing so, you would then bring that application to the High Court and have the assessment set aside. That is a quick process. That would take place within a year, not the 7 years or 5 years or whatever that I referred to earlier. That's a very, very quick process, but you've got to know what you're doing. Now, I successfully did this. If I go back to my slide, sorry, and it's not, this is not the correct reference. This is Pretoria East. Let me just change that, which I've referred you to. Okay, if I go to ITC 1921, which is something that you can look up, this was a case that I argued in 2018 in the Port Elizabeth Tax Court, and it concerned a CEO of a company whose employment had been terminated. He had received a very large separation package as part of a retrenchment benefit that was set out in his tax return, and then he had claimed significant farming expenses, and of course all of this was now in dispute with SARS. When the papers arrived, it was way beyond the tax audit stage. I looked at the papers and I said, but hold on, where's the letter of findings? If we look at Section 40 and 42 of the Tax Administration Act, I don't see a letter of findings. I don't see notification to the taxpayer that he's subject of an audit. And we found that there was none. So in legal terms, today we would have brought this application that I've just referred you to. We introduced an in limine argument. So in other words, we said to the court, before we delve into the merits of this case and go through all the evidence, I want to raise a point of law, and that is that SARS has failed to execute a compulsory step in the process of raising the revised assessments. It had failed to conduct administrative action which is lawful. It had failed Section 33 of the Constitution and the Promotion of Administrative Justice Act, and it had violated principles of legality and administrative justice. Guess what? Court found in our favor. We did not have to go through all the evidence. The court set that assessment aside. So really an important judgment. And this judgment has been, I'm trying to, here we go. Again, it's also referenced in the textbook that I told you about, setting out Section ITC 1921 and a failure by SARS to abide by the provisions of Section 42. So I cannot overemphasize the importance of that. So that should give you enough information to believe what I have to say, and maybe some of you have got examples of where we could apply it. Common audit pitfalls. In general, oversupply of information. You need to be very specific to what you respond to. If you end up going the letter of objection, so let's say SARS has issued a letter of findings, you've responded properly and in detail, it raises revised assessments. Very importantly, you ask for the reasons for the assessment. If those reasons for the assessment differ from the letter of findings issued by SARS. Remember the section I showed you a few slides back? SARS should have issued a new letter of findings. Their failure to do so means that the assessment stands to be set aside. So it is very important for you to ask for the reasons for the assessment to see if those reasons match what was said in the letter of findings, because again, you should have been given an opportunity to respond to any change. So please take that into account. Then in the objection itself, it is very important that you lay out all the procedural grounds. In other words, any defects that might have taken place. Now, the Constitutional Court recently in March of this year said that the tax court does not have the power to deal with administrative conduct issues. That is something for the High Court. So what we've always done in the letters of objection is we've raised all the procedural defects, and I most likely would do so in any event, but then say that the taxpayer reserves its right to raise these in a court application in the High Court if that hasn't already been done so. Now, on that note, you need to remember, if you are going to challenge SARS on procedural grounds, you have 180 days, which is 6 months, from the time that SARS has made the defective administrative conduct. If you miss the 180-day deadline, then it's prescribed. And as I said to you earlier, if you don't use it, you lose it. So if you're going to do that, it is very important you do so within the 180 days. The tax court itself is no longer given the power to deal with procedural issues. So as much as you might raise them in your objection, I don't think they're going to get you very far, although it depends on the procedural grounds, because there might be other procedural grounds that you raise in terms of the rules of the tax court, of which there are many rules and there are many transgressions there. For instance, oftentimes SARS doesn't meet the time limits imposed on them. And then there are certain procedures which can then be implemented, but that's for another day. And then, of course, the legal grounds. But any of this has to be premised by very strong factual grounds. And here I want to go back to the tax risk process. And I've mentioned in the past, if there are any procedures in your corporation that required sort of supervision by a internal tax executive or manager, whatever the case may be, when you get to the tax court, oftentimes the individuals that were involved are no longer available. They've moved on, they've changed careers, whatever the case may be. And there is a general rule against hearsay. You cannot rely on hearsay evidence in court, but there are several exceptions. And one of them is a legislated exception that if the manager in question had committed what they had done to writing and signed it off, not in an affidavit, just a statement and signed it off, it's their writing, that is one of the areas that an exception to the hearsay evidence rule exists. So it's really important, if you're embarking upon any important changes that might have tax implications for your business or your affairs, that the party that was seasoned with managing that process commits what was done to writing, so that if they're not available down the line to give evidence, that evidence can in fact be produced later on in a court of law. As far as procedural grounds, we've dealt with that. SARS's overreach, I think I've dealt with that sufficiently. I've dealt with the building of a tax risk management file. Again, those of you who have an interest in developing this, please remember what I said about the course, or at least reach out and obtain a copy of my tax intelligence book. I also have a summary version of it, which I'm happy to share with you. Tax risk management checklist. These are issues that I've dealt with in my previous webinars. Not much more that I want to say here. Practical takeaways. Again, manage those audits. And that's from the moment, that's from the tax risk management process. Many of you just don't have the capacity to do so. At least that when SARS reaches out, take control of what they are asking for, why they're asking it, what is the nexus, with whatever? Is it something in the industry? Try and understand what they're looking at and specifically address that concern. Know your rights and protect them. Realize that there are time limits. So if you're going to act upon these rights, make sure you've got the proper advisors standing behind you and act on those rights in the short period of time that normally exists. Documentation. If you end up having to go to tax court, the facts are what is going to win the day. And there you need to make sure that particularly complex transactions have been properly documented, including an explanatory statement signed off by the individual that was in charge of that. Willem, I think that's really all I want to share. I think let's end it at that. And if you do your short presentation, I can take some questions.
Great, thank you, Daniel. Yes, thank you for that. Let me just quickly tell you a little bit more about this tax risk insurance policy that Dr. Erasmus has been telling you about. I'll take 5 minutes of your time, and then we will get into the questions and answers. I hope you can see my presentation there. I think you do. You should. Right. So just very quickly, what tax risk insurance is all about. So this is the definition for it, and if you don't need to take scrupulous notes, because I'll be sending you some information about it after the presentation in any event. But really, it's effective insurance against SARS tax audits and related disputes, the subject matter of today's discussion. If an individual, a business, or trust is selected for audit, or if there's a dispute about an unfair tax assessment in terms of which SARS is demanding additional taxes, then tax risk insurance will appoint and pay for the team of tax professionals to deal with the matter to ensure a fair audit outcome. I think that's fairly straightforward. It is the theme of Dr. Daniel Erasmus's presentation today. These are the people who can benefit from a cover the most. It's companies, trusts, business owners and directors, and high net worth individuals. Really that category of taxes that's more complex than your average salaried earner. And as Daniel had said, for companies, our target market is more the small to medium-sized enterprises. For the obvious reason is that they don't necessarily have the resources to fight a fair battle with SARS. So what we're asking is these taxpayers to pay a small amount of premium into a tax pot, into an insurance pot, and then when there is a problem, then the resources are made available to give you a proper defense against this big machine called the South African Revenue Service. These are the categories of taxes that we cover. So really almost all local taxes. When I say almost all local taxes, we concentrate on the local taxes, not the international tax affairs. And then almost all, because there's specific taxes that we do not cover. This is a summary of what we don't cover. Tax evasion, of course, is we don't cover. You must pay your taxes as due, but only what is due. Then, of course, income generated outside of South Africa, international tax, customs excise, exchange control and transfer pricing. So those are all the international tax categories. Specifically excluded is employment tax incentives. So if you're involved in that area, we do not cover it for specific reasons. I'm happy to have a conversation with you after the fact. And then, of course, the normal preparation of your tax returns and the supply of supporting documentations or the verifications. Those are your normal tax returns, so you still remain responsible to pay those. And then, of course, in the final analysis, if it is found that you actually do pay SARS money, you are responsible for your own back taxes, interest and penalties. As far as the interest and penalties are concerned, we'll do everything within our power to negotiate with SARS to have better terms and maybe get those reduced or waived, which we're often quite successful in. So the benefits, of course, to use removes the uncertainty. It's an insurance product after all. So by the same way that you choose to insure your car or not to insure your car against accidents, this is the same equation. So we know we have a risk, and you now have the opportunity to insure that risk. Premiums are affordable, and I'll give you some information after the presentation how you can calculate your own premiums. Cover is retrospective, and there's no waiting period. So if you start your cover today, we will cover you from today for any period in the past that SARS has a look at. And so the rest is just straightforward. So I'm not going to go through much more information, aside from the fact that this is what an application form looks like. It's really a one-page application form. Doesn't matter if you're individual a company or a trust, you indicate to me on application form what that is. This is what the rate chart looks like. So for companies, individuals, and the trusts, so you can look up what your own insurance premium is when you fill out the application form. And we include a summary of the cover on the first page, so you're immediately aware of where the cover limits and cover benefits are. So that's it for this presentation. Let me just stop sharing this because I think we need to get to some questions and answer, Daniel, if that's okay with you.
Certainly.
But we have a question from Rodney. I think there's more than one question in a similar vein. Hello, Rodney. He says, Prof, good afternoon. If the taxpayer is successful in getting an audit set aside, can SARS reopen the same matter by starting the entire process over again for a second time?
Yes, so timing is important. If the assessment has been set aside and prescription is looming, and there's no reason for them to set aside prescription because of not non-compliance, but not having reported something previously, then that's the end of it. I mean, I give the example of a large mining company that I did this for. We agreed on the terms of the actual audit, and SARS were very tardy in responding, and then literally a week before prescription, they issued a very quick general letter of findings which didn't address the elements of what was agreed that the audit would be about, which we had given them substantial information. And we wrote back and said, no, we're bringing an urgent application to set aside your letter of findings because it's invalid. Long story short, they agreed, and we had the withdrawal made an order of court. That was the end of the matter. The next day, the matter prescribed. Obviously, if this happens early on in the process, they can re-engage. So it's just a question of timing. And again, it's the reason why you need to try and understand what it is that they're looking at. Why are they auditing your client? And that will oftentimes inform the direction you need to take.
Thank you. Jaco asks, we have all received generalized and automated letters from SARS for verification. What is the proper way to respond to these letters if the documents they mention in the letter is not related to your client? For example, if they ask for an IT3, but your client doesn't have any.
Just that. I mean, you would respond to say, you've obviously, remember I told you there's got to be a relevant material for the administration of the Tax Act. So if a document is requested that has no relevance to your client, then you say so. In terms of the Tax Administration Act, you're entitled to audit the client and request any material relevant for the administration of any tax act pertaining to the taxpayer. The IT3, whatever that you've requested, doesn't exist for this particular client, never has, or whatever the case may be. You clearly are addressing it to the wrong party. And we expect a termination letter from you. If you are not going to terminate this this verification process, then we would expect you to issue us with a letter of findings explaining why you propose raising any additional assessment against the taxpayer. And that covers you on both scores.
Great, thanks. Karen asks, can you please confirm objections need to be filed within 30 days and not 80 business days? I suspect something from the presentation. Objections need to be filed.
Yeah, we just need to check I don't know if there's been a change in the, I don't know if my initial research said 80 days, and then I went back to the Tax Administration Act, and my understanding was that it was 30 days. I think in fact, let's just take a look at just go to the next question. I'm going to just look up the tax court rules and just see what that now says. But you would take a look at the tax court rules.
Okay. Right. So I have a question from Sophia. If I may ask, how would one handle SARS since they implemented the ring fencing on losses on CGT? Client had a loss on purchases of derivatives, and now SARS has hit him with an amount payable.
It's too complex. It's not something I can deal with in a seminar like that. That's a question we'd have to deal with offline. That's a very specific problem. I'm not in a position to deal with that. I'm so sorry.
Yeah.
It's just not the right forum.
Mike asks, what about revised assessments because you did not give verification docs on time or when you have asked for an extension to submit supporting documentations?
Same thing. SARS is expected to give a letter of findings. You need to emphasize that. So you need to make sure that you've documented any extension of time requests, and in that, in any engagement with SARS, any subsequent engagement to information being requested by SARS, you remind them of Section 42A and 46, Section 42.2A and Section 42.2B. And the first response to say, please take note of this. We're asking for an extension. If you decide to take any further steps, we're expecting a letter of findings from you. So you need to take that first step.
Okay. Kulani has an answer to our question from before. He says 80 days from the 10th of March 2023.
Okay, great. Thank you. That answered the question. Yes, I did say 80 days and I thought, wow, that doesn't look right. Okay, so there was a change. Thank you, Kulani. Thank you.
Right, I think I have one final question. This might fall into this definition of specific questions. Let's see. So if SARS is asking for a case that I'm busy with, an IRP5, but the client qualifies for foreign employment income exemptions, how best do we respond? SARS is asking for proof of all expenses claimed with proof of payments, etc., etc. Do we just give them a copy of the employment contract, copy of the passport? Specific case?
Again, it's a very specific question. It's very hard for me to address specific facts in this forum. It's not wouldn't be fair on your client, and I can't give a definitive answer if I don't have the facts. You know, I can give a generalized. I mean, all I can say to you in terms of addressing an issue, make sure that you are giving SARS the information that will assist them in coming to a conclusion that will favor your client. So you don't want to give them too much information that might open up other areas of investigation. So again, without having assessed all the facts in question, it's difficult for me to tell you whether that would be the correct way to address it or not. Sorry, it's just a specific set of facts like that. It's very dangerous to address it in a forum like this.
Great. Tatiana asks, we have a client that ordered for 7 years of assessments when an AIT application was submitted. The letter was issued on 15th October of this year, and we had no additional feedback from SARS or letter stating who the auditor is. How long does SARS have to issue a detailed letter?
Have these periods not prescribed?
Doesn't say. Tatiana, maybe you can make a comment if you're still around.
You know, in the past, when we've dealt with SARS and we've tripped them up, a response from them oftentimes is no response at all. So sometimes clients want a definitive response. SARS actually have to give you a definitive response, but sometimes you don't want to push them in that direction, and you rather want the matter just to tick along until prescription comes and goes. Once the matter has prescribed, that's the end of the audit, unless there is non-disclosure on the part of the taxpayer. So you're wanting to play those times. If SARS is not responding and the 3-year prescription period is looming and it comes and it goes and they now respond, it's like, sorry guys, unless you've agreed to extend prescription, the matter's prescribed, and unless you explain to us that there's been some sort of non-disclosure, we don't need to address this matter any further.
You probably also need a lawyer to help you out with that sort of wording, right?
Most likely. I mean, you know what? Yeah, once once you're dealing with non-disclosure is a tricky area, and again, that in itself is a whole lecture. But yeah, if prescription has come and gone, and it's taken this long for them to audit, why are you even dealing with it?
Okay. We have one last question. From Noel, who is defined as a senior SARS official?
So that is a good question. I think that is dealt with in the Tax Administration Act. Let's see what it says. Let me just get hold of it again. Bear with me. I just got to open that. Huh. Where's my act?
While you're there, there's another question also from Corin. Is there something related to prescription in the Tax Administration Act, and what section?
There are various, yes, it is dealt with in the Tax Administration Act, and there are various prescription dates that apply to different types of taxes. These are, yeah, so if people have this type of basic information, and again, this is information we run through our entity, we run a local Tax Administration Act course that will address a lot of these questions. So this is sort of basic training that all of you should embark upon at least once every so often. And there are updates. I mean, just like now with the 80 days, and I wasn't aware of the 80-day change. I work in different jurisdictions. I would really suggest that you do the tax administration, tax dispute course, the short course that we offer. Not that lengthy tax risk management course I showed you earlier, and it will address a lot of these issues. These are fundamental issues you need to be you need to have your fingers on them. It's really important, because if you don't, I mean, there are various prescription periods that are available depending on the type of tax involved. Sorry, I'm just trying to get hold of the tax administration. Just if you look in the Tax Administration Act, it should define who a senior SARS official is, if memory serves me correctly.
Looks like Kulani might have an answer. Let me just check. I saw his answer came in. Kulani says the senior SARS official is an official within the South African Revenue Service who has been granted specific written authority by the Commission, who occupies a post designated by the Commissioner to exercise certain powers and duties under the TAA.
It would say so. Quite right. Thanks, Kalani. Yeah, so it would say so in the notification that that the person produces, and it's a good question. Don't underestimate this. In that, in one of the cases I argued in PE, we nearly won, and this was for a taxpayer who hadn't filed any tax returns. And we caught SARS with their pants down that the person who had conducted the audit was not properly authorized to do so. And the matter was actually thrown out of court, and the SARS officials brought an urgent application later that day and managed to find some sort of delegation of powers that had given this person the power to do what he was doing. So if the person is not properly empowered, it's a fundamental problem for SARS. So good question. You should definitely scrutinize those authorities that they present and ask for them, because they make mistakes, and it has to be a person who's properly authorized to be able to conduct that type of investigation.
Great, good question. Daniel, I think that brings us to the end of the session. If I can ask the audience if there's any more questions, I will be sending you out an email during the course of tomorrow. It will have my contact details on. By all means, if you have any questions, just ask, and then we'll provide you the answers the best we can. So it just leaves me to say thank you to Greatsoft for hosting us for this event. Thank you, Dr. Erasmus, for being the keynote speaker during the series. I think it's been valuable, and thank you to the audience for attending the session. Thank you very much, and enjoy the rest of your afternoon.
Thank you, everybody. Thanks so much.